Good afternoon, all. And today's video is a follow-up to my previous video about the Florida State Courts admitting that being autistic is vexatious in enacting an autism segregation vexatious statute. They don't just stop there. What they do is then when autistic people or their families or both go into the revolving door of bankruptcy, the state courts double down and it gets far worse. And they're doing this on purpose. So let's start with the basic problem of what it means to be autistic in a neurotypical majority designed world. The lifetime cost of autism can range from $1.4 million to $2.4 million, depending on whether the person has an intellectual disability as well. The cost can vary widely and includes medical, economic, social, and psychological factors. Some of the costs associated with autism include medical costs, occupational therapy, lost productivity, and informal care. And these are huge costs. Why it matters. Autistic adults may very well be the most disadvantaged disability group. Without gainful and sustained employment, adults with autism live at or below poverty levels on the welfare system of the state. Why it matters. The Thinking Person's Guide to Autism here relates, I am not the only disabled person economically struggling, as disability and poverty go hand in hand. Why is that? The answer is complex, since disability leads to poverty and poverty leads to disability. It's a vicious cycle and sometimes a downward spiral, leading people to lead lives perpetually circling the drain, always on the edge of annihilation. And in There Is No Epidemic of Autism by John Elder Robison and Dina Glassner. Here's the site. They say, too often autistic adults without the benefit of privileged family live in squalor at risk of abuse and neglect. Anyone taking social services funding is forced into penury with income capped below the poverty level. Their benefits are constantly under restriction, and they endure an unending burden of proof to keep their supports. This leaves most autistic people and their families ineffectively supported. The implications of this failure are everywhere. In the quest to help their kids, parents, usually mothers, sacrifice their careers and identities. So there are plenty of articles out there specific to autism and autistic people that show the reason why there's a revolving door to the bankruptcy court for autistic people and autism families, who, if anyone studied it, would clearly be shown to make up the majority of the 66+% of bankruptcy filers every year with medical debt. So, given that the Florida State Court System's autism segregation vexatious statute is, as they admit, targeting autistic people by saying being autistic is vexatious, it comes as no surprise that autistic people will file for bankruptcy and have pending bankruptcies. And what is the reaction of the Florida courts task forces and Florida bar members who are inciting and encouraging the expansion of the number of autistic people put on these vexatious segregation lists and registries? What is their response to this? Well, according to a 2022 study 66.5% of all bankruptcies were tied to medical issues. Medical debt is the leading cause of bankruptcy in the United States. In addition to medical debt, other causes of bankruptcy include work loss, or when someone does not pay a person for the work or services the person performed for them. Within the whole body of these vexatious autism segregation materials that I referenced in my previous video, the Autism Segregation Vexatious Statute of the Florida Court, there were at least 3 references when they were asking, well, what types of cases are these people bringing? To at least 3 of the people they have labeled so-called vexatious and put on this vexatious registry were in pending bankruptcy cases. And here's what they have to say about that. Divorce, bankruptcy, foreclosure, unemployment, and civil liabilities in the form of fines and opposing parties' attorney's fees are substantial stressors that may co-occur with litigants' fixation on their legal matters. These grievances with their own circumstances may mean they are now actively working against the interests of efficient case processing, wherein stymieing the process and burdening the court actors may be the goal rather than the resolution of the issue at hand. And that is at page 17 to 18 of Sarah Harper's dissertation. The Florida Bar gave a continuing legal education in late 2023 entitled Florida's Playbook on Vexatious Litigation. We're not going to take it anymore. And they stir the prejudices against these autistic people. The Florida courts admit as targeted on this autism segregation vexatious list that by calling them litigant gone wild. And then down here, they're saying, like, what is the motivation for this problem? Where is it coming from? Dissatisfaction, aspirational, emotional, psychological, and last stop. Well, what makes the Florida Bar and these Florida lawyers and judges, the dissertation by Sarah Harper, the task force report, what makes them all assume that the reason somebody would file more than 5 cases and would have to file a greater number of cases would be that they're emotional and they're stressed out? What makes them think that? See, what makes them think that that is stressing the person out when the primary goal of the bankruptcy is the relief that comes with a fresh start? That's a reliever of stresses. And in addition, many people who would file a bankruptcy, they may have businesses and understand it's a turnaround tool. It may be a reorganization so they can be put on more solid financial footing because maybe a customer like cheated them out of paying a bill or many bills. So there may be any number of reasons that have nothing to do with stress. And certainly somebody who went to law school, somebody who took a class in bankruptcy law, and this is a prime reason what's happening in Florida, is a prime reason they probably should withdraw ABA accreditation to all Florida's law schools and to Florida's bar exam until such time as every lawyer and judge in Florida is required to take a bankruptcy course. Although mentioned nowhere in the U.S. Bankruptcy Code, fiduciary duties play a central role in guiding the administration of an insolvent debtor's assets. The chief actor doing that administration is the bankruptcy trustee, who is subject to a host of duties, some of which are unquestionably fiduciary. Chapter 13 is a special reorganization for individual debtors where they may propose their own repayment plans spanning 3 to 5 years, paying over net income to their creditors but retaining all their property in exchange for debt discharge at plan completion. Although the trustee is primarily regulated in Chapter 7, separate provisions of the Code prescribe special rules for trustees in Chapter 11 and 13. Fiduciary duties. The absence of an explicit rule of fiduciary does not undermine the Bankruptcy Code's language that is clearly amenable to trigger such responsibilities, such as the primary instruction to collect and reduce to money the property of the estate can be interpreted, and indeed has been by courts, to impress upon trustees a fiduciary role. And the citation for that is here. In a Chapter 13 bankruptcy reorganization case, the debtor has almost all of the rights and powers of the trustee. The debtor in a Chapter 13 case is considered the debtor-in-possession. The debtor-in-possession has many of the same rights and powers as a trustee. Chapter 13 is a type of consumer bankruptcy that allows individuals to reorganize their debts over time. The term debtor-in-possession refers to the debtor in a Chapter 13 bankruptcy case who has many of the same rights and powers as a trustee. So, if I go into a circuit court and I say, "Hi, Judge, I'm a debtor in a pending bankruptcy case," and then give the case number, the name of the case, the court, the federal bankruptcy court it's pending in, and that it's a Chapter 13, that puts the Florida State Circuit Judge under a duty to know that as a debtor in a Chapter 13 case, I'm a debtor in possession with almost all the rights and duties of the bankruptcy trustee. So, in 1978, Congress of the United States overhauled the bankruptcy laws. And Congress tried to make a very broad jurisdiction so that the bankruptcy courts could decide all matters involving the bankruptcy in the case administration in the bankruptcy court. But after that, there were some cases, of which Stern v. Marshall is one, right here, that struck down that broad grant of jurisdiction. And the upshot of it is that the Supreme Court of the United States requires bankruptcy courts to kick matters involving the administration of a bankruptcy case that are state law claims into the state courts. And so it's implied in Stern v. Marshall that the state courts have to be willing to accept these cases. Because if they don't, the bankruptcy debtor cannot administer the bankruptcy case. So, for example, if somebody owes you money for providing services like happened to me, and the bankruptcy court has to send those claims into state court under Stern v. Marshall, Stern v. Marshall is binding on the Florida state courts just as much as it is on the bankruptcy courts. And it's a little more than, well, is the person emotional or stressed out because they're filing cases because they're in a bankruptcy? No. The task force, the dissertation by Harper, the Florida Bar's legal education on the Vexatious litigation playbook, they all missed the boat. That if there's a bankruptcy, there may be conflict of the laws between the federal bankruptcy law and the state vexatious claim when the debtor is a debt possession in a Chapter 13 reorganization case like I was. And that is because as debtor-in-possession, I had the duties of the trust, and some of these were fiduciary duties to recover money owing to me and my estate. So I was owed money for teaching writing lessons and giving equestrian services, and I was told I had to go to state court. And also, there were claims that were involved the horse farm, where the seller's lawyer failed to conduct the closing properly. And so that put more state law claims coming out of the bankruptcy into the state court. And so I had a horse business. If I had a horse boarding business like I previously had, I could have 10 or 15 horse boarders that are not paying their boarding contracts. So I could have more than 5 cases. And for me not to be able to go into the state court to administer my bankruptcy case would, number one, obstruct my bankruptcy case. Number two, it would put me in a catch-22 where if I did not file the cases, I could be sued by creditors for breach of fiduciary duty as the debtor in possession to not recover this money. But if I do, then the Florida State Court wants to stop the bankruptcy, especially if it's an autistic person. Being autistic is vexatious. They admitted it right in their documents posted on the Florida Courts website. And they don't want to allow more cases than 5. So they're actively obstructing a bankruptcy. And it is not my fault that a slew of state court lawyers and task force members and people giving Florida bar CLEs and a circuit judge had zero knowledge of bankruptcy law. Because when I filed one of the causes of action in the 13th Judicial Circuit, the Honorable Claudia Isom put right at the beginning of one of her first orders, this is a co-ed in action asset of the debtor in possession's bankruptcy estate. So if one Florida judge had enough knowledge that I was in a bankruptcy and the lawsuit was an asset of the bankruptcy case, then there's no excuse that another circuit judge would not have that knowledge, that the Florida Supreme Court's task force would not have that knowledge, that all the lawyers and judges putting on the Florida Bar continuing legal education would not have that knowledge. Why don't they understand bankruptcy law? They just want to obstruct the administration of a bankruptcy case and a fresh start for all these people on the task force, who the two Chief Justices of the Florida Supreme Court assigned to research this law. Well, for them not to understand bankruptcy, that is a huge failure. And when they say, well, we look to other states, the other states with these shortcut vexatious statutes, well, first of all, none of the other states actually posted documents to their Florida court's website that said, being autistic is vexatious. Actually, autism segregation list. But even more so, the Florida Task Force and the clerk of the Florida Supreme Court, John Tomasino, and the Florida Bar CLE on the Florida Playbook on Vexatious Litigation, they're not looking to what all the states have done. They only cherry pick the ones that have more recently, in the 200-year history of our country, have made these shortcut legislative statutes to bypass what used to be the accuser had to bring a full-blown civil vexatious litigation lawsuit with discovery and and with admissibility of evidence requirements and a burden of proof against the accused victim, because they didn't look to what the state of Connecticut had to say. And what did the Connecticut have to say? Well, in Florida, the highest court of the state is the Florida Supreme Court. And the Autism, Segregation, Vexatious task forces say that they have looked to other states and how they've handled this so-called vexatious problem. Well, if you flip a coin and you're a judge, about half of the judges will say the same claim has merit, as the other half of the judges say that it's frivolous and vexatious. So you don't even have a consensus. You have a coin flip. Those are the odds. So this statute in Florida doesn't even do what it says it does. There is such a disagreement even among the state court judges as to any one single claim as to whether it's meritorious or it's not. It's 50-50. Since Florida their task force looks to other states to see what they're doing, we're going to take a look at the state of Connecticut. One of the states the task force deliberately omits initial and final task force research and report. Who is the Connecticut Supreme Court? It is the highest court in Connecticut. Basically, it's the equivalent of the Florida Supreme Court. So if the Chief Justice is going to assign task forces to research the Autism, Vexatious, Segregation statute, and Connecticut would be one of the states they ought to be looking at. So, being that I was in a Chapter 13 bankruptcy, and Connecticut Supreme Court has spoken on what happens to the operation of a segregation vexatious law when the person you want to use it against is in a bankruptcy. So, let's look at Connecticut. Now, you have to know something about the history as vexatious and segregated court system tracks. And most of these laws, like Florida's, is brand new. It's like an experiment. Like the victims are guinea pigs. The long history of the courts and litigation in the United States, going back to the founding of this country like over 200 years ago, didn't have these kind of newfangled laws to segregate certain classifications of people. In the history of labeling certain classifications of people, such as Florida and autistic people, vexatious, in the history of the country, a full-blown civil lawsuit was required. In other words, one of the most important things about this process is that if, say, an autistic person was advised by a sheriff they need a restraining order against a person who is exhibiting violence against them, if an autistic person was advised by a licensed bar member they have a valid claim and need to bring a lawsuit to get their medical care paid for against an insurance company, or that they got swindled in a land deal by a property seller's lawyer, that the person had a valid claim and needed to sue to keep their home, or if the autistic person was advised by autism organizations, disability organizations, or agencies that they had to sue to collect money and resources owed to them, such as working for money and not getting paid, then in this full-blown civil vexation lawsuit, the subjective motivations and intents of the autistic person in filing the lawsuit, say to collect the money that was owed to them for the work they did and the services they provided, that would be allowed to come out, and it would serve to negate the elements of a vexatious claim, and it was served to defend against a vexatious claim because there's nothing harassing, there's nothing frivolous, there is nothing vexatious in asking to be paid for money you're owed for work that you did, especially if you're vulnerable, disabled adult who is autistic, or you're elderly. Not like what Florida did with their autism experiment to exclude autistic people they don't like by just taking a shortcut and chopping out through the shortcut an entire civil lawsuit and just making a labeling that person. And that law stresses what happens when the person they want to put the vexatious label on filed a bankruptcy, was in a pending bankruptcy. Vexatious litigant sanctions were put on a person who was a plaintiff in a lawsuit who was also in a bankruptcy. The plaintiff there had a business and was in a Chapter 11, which converted to a Chapter 7. In another Connecticut case called Lewis, an appellate court held that bankruptcy law preempted vexatious litigation claims. Because the exclusivity of the federal jurisdiction over bankruptcy proceedings, the complexity and comprehensiveness of Congress's regulation in the area of bankruptcy law, and the existence of federal sanctions for filing of frivolous pleadings in bankruptcy must be read as Congress's implicit rejection of alternative remedies in bankruptcy must be read as Congress's implicit rejection of alternative remedies such as the vexatious litigation claim in the state court. The Connecticut Supreme Court first turned to the Supremacy Clause of the United States Constitution, U.S. Constitution, Article 6, Clause 2, providing that the federal law shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding, under this principle, Congress has the power to preempt state law. The Connecticut Supreme Court continued. The Bankruptcy Clause of the United States Constitution grants Congress the power to establish uniform laws on the subject of bankruptcies throughout the United States. U.S. Constitution, Article 1, Section 8, Clause 4. Through Title 11 of the United States Code, Congress provided a comprehensive federal system of penalties and protections to govern the orderly conduct of debtors' affairs and creditors' rights. The Bankruptcy Code impliedly preempts the plaintiff's state law vexatious litigation claims for two main reasons. One, Congress legislated so comprehensively as to occupy the entire field of penalties and sanctions for abuse of the bankruptcy process, leaving no room for state law to supplement. And two, the federal interest in uniformity is so dominant, it precludes enforcement of state laws that threaten the uniformity and finality of the bankruptcy process for debtors and creditors alike, thereby implicitly preempting state law vexatious litigation claims. It is very unlikely that Congress intended to permit the superimposition of state remedies on the many activities that might be undertaken in the management of the bankruptcy process. The highly complex laws needed to constitute the bankruptcy courts or regulate the rights of debtors and creditors also underscore the need to jealously guard the bankruptcy process from even slight incursions and disruptions. Nothing less than the Constitution of the United States persuades us that Congress's interest in uniformity in the bankruptcy process is so dominant as to preempt collateral attacks through state vexatious litigation claims. The Constitution grants Congress the authority to establish uniform laws on the subject of bankruptcies throughout the United States, U.S. Constitution, Article 1, Section 8, Clause 4. It is obvious that if the power is exclusively vested in the states, each one will be at liberty to frame such a system of legislation upon the subject of bankruptcy and insolvency as best suits its own local interests and pursuits. Under such circumstances, no uniformity of system or operations can be expected. The Connecticut Supreme Court reasons. State courts have concluded, as we do, that permitting state law claims for abuse of the bankruptcy process threatens the uniformity of the bankruptcy system. Allowing state tort actions based on allegedly bad faith bankruptcy filings would have the effect of permitting state law standards to modify the incentive structure of the bankruptcy code and its remedial scheme, threatening the uniformity of federal bankruptcy law. Connecticut Supreme Court continues. It is foreseeable that states might disagree over the standard to be met. State courts are not authorized to determine whether a person's claim for relief under a federal law is an appropriate one. Such an exercise of authority would be inconsistent with and subvert the exclusive jurisdiction of the federal courts by allowing state courts to create their own state. Varying standards for recovery from state to state would serve to undermine the federal interest in uniformity. Second, permitting state law actions would allow parties to collaterally attack the bankruptcy process, threatening the finality of the proceedings, as well as the ability of the parties, debtors and creditors alike, to make a fresh start once the bankruptcy proceeding concludes. One of the overriding purposes of the Bankruptcy Code is to provide debtors with a fresh start. It is the purpose of the Bankruptcy Act to convert the assets of the bankrupt into cash for distribution among creditors, and then to relieve the honest debtor from the weight of oppressive indebtedness and to permit him to start afresh, free from the obligations and responsibilities consequent upon business misfortunes. The potential threat of state court actions following on the heels of a bankruptcy proceeding may well interfere with the necessary actions that creditors take within the bankruptcy process. The mere threat of actions could prevent individuals from exercising their rights in a bankruptcy, thereby disrupting the bankruptcy process. The Bankruptcy Code impliedly preempts state law vexatious litigation claims. The Bankruptcy Code provides the forum, incentives, penalties, and sanctions that apply uniformly to debtors and creditors nationwide. Vexatious litigant claims are still preempted under a conflict preemption analysis because they are an obstacle to accomplishing Congress's purpose within the Bankruptcy Code. Conflict preemption exists when compliance with both state and federal law is impossible, and a subset of conflict preemption referred to as obstacle preemption applies when the state law stands as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. State law is irreconcilable conflict with federal law and hence preempted by federal law when compliance with the state statute would frustrate the purposes of the federal scheme. We can imagine a myriad of claims that would lend themselves to vexatious litigation actions, including debtors' petitions, creditors' claims, disputes over reorganization plans, and disputes over pending discharges, to name a few. If such claims were not preempted by federal law, redress for them would depend on the law of the state in which the plaintiff brought the action. Permitting assertion of a host of state law causes of action to redress wrongs under the Bankruptcy Code would undermine the uniformity the code endeavors to preserve and would stand as an obstacle to the accomplishment and execution of the full purposes and objectives of Congress. Accordingly, plaintiffs' vexatious litigation claims are in conflict with the Bankruptcy Code purpose and thus are preempted under conflict preemption as well. Referring to my previous video on Florida's Autism Segregation Vexatious Statute, the only viewpoint of this Chief Justice in his assignment to the Second Task Force is that the Autism Segregation Vexatious Statute is under-inclusive. It's not including enough people who should be included. But then he's not addressing that it's over-inclusive, that it's including people who should not be included. Autistic people should not be labeled and classified vexatious because we're autistic. So it's over-inclusive in that way. But it's also, if you consider looking to other states and what they are doing and the Connecticut Supreme Court, if this person you want to target with this vexatious statute has filed a bankruptcy and is in a pending bankruptcy, the state's vexatious claim is preempted by federal bankruptcy law. So, if I file a Chapter 13 bankruptcy and I live in Connecticut, I will not be subjected to autism segregation vexatious claims brought by a disgruntled creditor of the bankruptcy in a state trial court because it's preempted. But if I live in the state of Florida, which I do, a disgruntled creditor, I'm a Chapter 13 debtor in possession with almost all the duties of the trustee. As set forth, I have a fiduciary duty to recover money of the estate from people who owe the debtor money. In many of these instances, I'm a debtor in possession in Chapter 13, and I have a fiduciary duty to go after these claims, and Federal Rule of Bankruptcy Procedure 6009 authorizes me to do so in the state courts of the state of Florida. And it authorizes me to do so in however many numbers of cases that I have to file to administer my bankruptcy estate. Do so to recover, to pay the creditors of the bankruptcy estate. Federal Rules of Bankruptcy Procedure Rule 6009, entitled Prosecution and Defense of Proceedings by Trustee or Debtor in Possession, specifically states that with or without court approval, the debtor in possession may prosecute or may enter an appearance and defend any pending action or proceeding by or against the debtor, or commence and prosecute any action or proceeding in behalf of the estate before any tribunal. That includes any tribunal in the Florida state courts. So, now, Florida's Autism Segregation Vexatious Statute conflicts on its face with this Federal Rule of Bankruptcy Procedure authorizing a Chapter 13 debtor in possession to be administering the bankruptcy case and pursuing recovery on causes of action that have to go into the state courts. So what is it about now the Florida courts are obstructing Chapter 13 bankruptcy case administration by erecting this Autism Segregation Vexatious Statute? What's wrong with that? Well, this is the docket for the tax collector case. Even though they call it by this title here, and here's the case number, it was also against the tax collector. Von Fraser is Alachua County tax collector. And here's the docket for the case. You can see there's a complaint. It's never gone to trial. There's never been any judgment entered. No appeal has been taken. It says that it was temporarily stayed by a suggestion of bankruptcy. And here's the other case right here. Case number, the case. It is the second case that's against Von Fraser, the tax collector, even though it has that heading. And here is the docket for that case here. There's a complaint. There's no trial. There's no judgment yet. There's no appeal yet. The case, the last event is temporarily stayed by a suggestion of bankruptcy right here. Now, licensed attorneys in Florida, Florida bar members, they are supposed to know how to read a docket. I mean, if a lawyer who's a licensed lawyer doesn't know how to read a docket, to know if a case is still pending, or alternatively, finally and adversely decided, if a licensed Florida bar member cannot read a docket, to be able to ascertain that information, then I don't understand why the Florida Bar has licensed the lawyer as competent. Here's a lawyer. We have a lawyer, Richard Henry Fabiani II, Rick. He's a member of the Florida Bar. This is the membership directory here. And Mr. Fabiani filed a motion right here in this case, and he made the allegation that this is a knowing, false, and fraudulent with scienter allegation that the following listed cases are finally and adversely determined. And he lists these two tax collector cases, the 3472 and the 5191, for which I just pulled up the docket because the dockets show that these cases have never gone to trial. So Mr. Fabiani filed this motion and he signed the motion here. And Mr. Fabiani obtained, on the basis of that fraud with scienter, he obtained an order under that statute listing the case 3472 and 5191, where the order states that those cases have been finally and adversely determined, and this is shown to be fraudulent and a falsehood by the dockets in the case. The order is signed by Monica J. Brazington, Circuit Judge, and it's in this case here. Mr. Fabiani doubled down on his fraud. He filed these motions after he made the threat against me. If you don't drop your claims against my client, I'll make sure you never get a bar admission anywhere. So he filed this motion here. And again, he made the knowing, false, fraudulent statement. Here's the cases, 3472 and 5191, the tax collector cases, falsely and fraudulently with scienter, told the circuit court they were finally and adversely determined, and he signed it here. Used this fraud to induce and obtain a second order from the circuit judge. Here's the cases, 3472 and 5191, and obtained the judge's ruling that those two cases were finally and adversely determined. That's in this case. It's signed by the circuit judge. And on the face of the dockets, it proves that Mr. Fabiani committed fraud with scienter against me to bully me because I'm autistic and put me on an autistic segregated vexatious list with the Florida Supreme Court, a registry maintained by John Tomasino, clerk of the Florida Supreme Court. Mr. Tomasino is also a lawyer. The autistic bullying rate, the bullying rate of autistic people is as high as 94%. So you can't say just because someone's a lawyer, someone's a clerk or a judge, that an autistic person is not being bullied. Not with a bullying rate as high as 94%. And we should know that autistic bullying is also wrong. But what else would you call this?
Hey, Paul, one of the points that you made, but each of these 5 cases have to be resolved with finality. In other words, the appeal is exhausted too, right? On each of those cases in order for it to be effective, correct?
Correct. Appeals, any pending petitions for review in the court, they've got to be completely over. And that's one of the limiting factors.
Mr. Tomasino, who is clerk of the Florida Supreme Court and maintains this Autistic Segregation Vexatious Registry, he is also a licensed lawyer. So he also would be required to be able to read a docket to know if a case is finally and adversely decided. And here is an order of the Bankruptcy Court entered on September 21st, 2018, signed by Honorable Catherine P. McEwen here. And this involves the tax collector. And this order specifically states that my husband and I sought review of the Alachua County Value Adjustment Board's findings by filing two separate actions in the 8th Judicial Circuit in and for Alachua County, Florida for each tax year. And these actions are still pending, and the debtors are free to pursue them. Okay? Those are the cases that I showed the dockets for. So the bankruptcy court has ruled that the cases are still pending, they're not finally and adversely decided, and that my husband and I are authorized to pursue them. Further, the bankruptcy court finds that should we prevail in either of those tax collector circuit court actions, resulting in a reduction of the taxes owed for 2011 and 12, the Alachua County tax collector is required to refund my husband and I any overpayment. And further, if there is a reduction and it changes the tax amount for following years, we should also be owed a refund to the extent of any overpayment of taxes for those subsequent years. Now, the Florida Supreme Court's clerk, John Tomasino, who is assigned by the Autism Segregation Vexatious Statute by the Florida legislature in his handling and maintaining Florida's vexatious litigant list, Mr. Tomasino has been a Florida bar member for a very long time. And so he has been, in that capacity, regulated by the Florida bar. And so he would absolutely know. Now, my husband and I paid more than $3,700, a little under $4,000 of those property taxes under our confirmed plan. And those property taxes included payment for a double-wide mobile home that was on the 11502 Southeast U.S. Highway 301, Hawthorne, Florida property. Well, we hired an appraiser, Joseph Monford Foy III, who did an appraisal of the real property located there, and that's the property upon which we paid these property taxes that pertained to the two tax collector cases that the bankruptcy court says were still pending, that the docket shows were still pending, that the lawyer, Fabiani, and the judge said were finally and adversely decided because I guess they couldn't read the dockets. And Mr. Foy had to give two different values on the appraisal for the property. The property as is, with the warranty deed that was recorded in the official records of Alachua County, was $25,000. But if the corrective warranty deed that was required was filed and recorded, then it would have been worth $70,000. Mr. Foy found that a corrective warranty deed was required because the serial numbers for the manufactured home located on the real property were incorrect. And so it required a corrective warranty deed and or a reformation count. Now, that never happened. No corrective warranty deed was ever made, delivered, or recorded in the official records. And no reformation count was ever brought to correct the wrong serial numbers in the warranty deed that we were given on June 18th, 2010. So both the Department of Motor Vehicles in Florida and the appraiser told us that we never had title transferred to us of the mobile home on the property. And the title remained in the seller, Darlene Baylor. So we never owned the mobile home, according to our appraiser, but we paid all these property taxes on the mobile home. So we should have been entitled to a refund. Of the major portion of that money that we paid under our confirmed plan to the tax collector. And that's what we were authorized to take forward by the bankruptcy court, was to ask for the refund of that money, because the cases were still pending. I wrote an email to Attorney Fabiani and told him that he was under a duty to inform the courts that he committed fraud to obtain these autistic segregation vexatious orders by saying that the two tax collectors were finally and adversely decided when the bankruptcy judge said they were still pending and we are authorized to take them forward, and that if we get a refund, we get to keep the money. It doesn't go to the trustee. And we copied this email to John Tomasino. And I actually followed this by calling Mr. Tomasino, the clerk of the Florida Supreme Court, to inform him about the bankruptcy order. And Mr. Tomasino said, "I don't care about no bankruptcy schmankruptcy." And then I said that you're disobeying an order of the bankruptcy court in Tampa that says these cases are still pending. I'm authorized to take them away. And Mr. Tomasino said, "I don't care about no bankruptcy court order." And so there is a question, because does the Florida Supreme Court supervise its clerk, Mr. Tomasino, regarding the Autism Segregation Vexatious Registry and what he's doing to name people to it and remove them if they're wrongfully placed there? In Article 1, Section 3C here, this is the Florida Constitution, it says the Supreme Court shall appoint a clerk who shall hold office during the pleasure of the court and perform such duties as the court directs. It doesn't say as the legislature of the state of Florida directs under a statute. The question about all this is the Florida Supreme Court supervising their clerk when the clerk is facilitating and aiding a lawyer, Mr. Fabiani, who committed fraud right on the face of the documents, to fraudulently say the two tax collector cases are finally and adversely decided, to count them to segregate an autistic person to a vexatious registry? Is the Florida Supreme Court supervising the clerk when he does this and disobeys a bankruptcy order that says they're pending and I can take the case forward? Or is the clerk acting in violation of that provision of the Florida Constitution? I.e., is his doing this to me unconstitutional under the Florida Constitution? Because what would I have done with this money? I would have paid for annual mammograms I had not been able to have, or at least every other year, mammograms and ultrasound. And had I been able to do that, it would have caught my breast cancer much earlier, before it went into 6 of my lymph nodes. And I had to have 27 lymph nodes removed. I would have paid for some of the dental care from the cow trampling me. I wouldn't have had a dental infection in my mouth that itself can cause breast cancer. So in sum, Mr. Fabiani, the circuit judge, and Mr. Tomasino, the clerk of the Florida Supreme Court, they are joint and several causes of the indivisible injury of my breast cancer. And 2, they progressed my breast cancer by the fraud and the falsification and putting these cases on this list to segregate me out of the court system. It's a confiscatory takings of money I should have gotten on a refund that I would have spent, and I wouldn't have suffered and have had my breast cancer go so far, because I didn't know about it, but I would have detected it much earlier and known about it had they not done this to me. So that's what happened. And so this is more doubling down on targeting autistic people as vexatious, because autistic people go into a revolving door of bankruptcy, and the state of Florida is trying to limit the number of cases to obstruct bankruptcies, and in doing so, it inflicted breast cancer and progression of breast cancer on me. And these are the people who did it to me. And this is just really, really wrong. I understand people can hate autistic people, but to wish this kind of harm on a woman, this is just wrong. It's wrong. If you like my videos and you'd like to see more videos, hit the notification button, subscribe to my channel, ring the bell, and you'll be notified when I post more videos, including more videos on this little series. Thank you for watching.